Good afternoon, everyone, and welcome. We are waiting for one more panelist to join us, and then we can start. In the meantime, just some housekeeping. Can use the chat box to let us know who is here and where you're joining us from. And we can use the Q&A box for any questions. And my name is Marie. I'm going to be your host for the day. To start us off, we'd like to let us know who our panelists are and why this conversation is important for us today. As we know, the African Commission, periodically and has consistently been putting out some soft guidelines for states, but sometimes as civil society, we are not aware of these guidelines, or we don't know how we can apply them in the work that we do. So today we are going to specifically focus on the recently launched guidelines on enforced disappearances, and we're going to contextualize the conversation using Kenya as a case study. But we are all welcome to bring in experiences from different parts of the world, your own personal experiences. I think most of us have personally been affected by disappearances directly or indirectly. We may know somebody who disappeared, or ourselves may have been a victim of disappearance, or we are working towards ending enforced disappearances. So feel free to share your perspective with us. As methodology, we're going to have a round of panel discussions, and then at the end of which we're going to have some plenary discussions. So to start us off, I'd like to introduce our panelists. Ms. Eva Nudd is a legal advisor with dignity, focusing on preventing torture in Africa and working to raise awareness on the use of non-custodial measures as a way to prevent torture in prisons and police settings. Prior to joining Dignity, Ms. Nudd was a legal advisor in redress on enforced disappearances, raising awareness about the crime of enforced disappearances and bringing justice to victims in Zimbabwe, Sudan, Libya, and Algeria. And she has helped the African Commission to draft the guidelines to ban enforced disappearances in Africa. Eva is a human rights attorney with vast experience in gender issues, women's rights, international criminal law in the United States, Europe, and Kenya. Prior to joining Redress, Ms. Nudd worked for the United Nations Environmental Program and the Open Society Justice Initiative in Nairobi, where she worked with victims of sexual and gender-based violence and police shooting of the 2007-2008 post-election violence to obtain justice. She also worked as an immigrant attorney in New York, advising asylum seekers, including victims of female mutilation, forced marriage, and domestic abuse. She obtained her law degree from Fordham University School of Law and has a master's in international relations from Seton Hall University. Welcome, Eva, and thank you for being here with us today. Our second panelist is Mr. Mwangi, who is a legal advisor on national, regional, and international human rights and humanitarian law. Mwangi is an innovative, dedicated, diligent legal professional with over 5 years global experience, working on human rights and governance. His practice is on legal analysis, legislative drafting, and public interest litigation, among other disciplines. Mr. Mwangi has amassed expertise in law reform, democratic governance, and constitutionalism at the national and regional level. He has worked extensively on projects that seek to realize the protection and promotion of human rights at the regional and global level, especially on extrajudicial killings and enforced disappearances. He has served as an expert member on extrajudicial killings and enforced disappearances at the African Commission on Human and People's Rights. He also sits in think tanks, fora at the regional level, which include the Working Group on Migration and Torture in Africa. He has vast experience in making submissions for vindications of rights before national courts and tribunals, as well as regional courts, international treaty monitoring bodies, such as the Human Rights Council, the African Commission, the African Court on Human and People's Rights, the SEDO and Human Rights Committee. He is passionate about using constitutional and human rights law to address systematic deficits in the protection of marginalized groups and communities and challenging legislation, policy decision, and administrative action offending the Constitution of Kenya and fundamental rights international law. Over his career, he has provided legal aid to over 300 victims of human rights violations through direct victim support, court users committees, medical legal camps, to name but a few. His work has seen him awarded the Law Society of Kenya Nairobi Corporate Lawyer of the Year 2000. He is an alumnus of the Young African Leadership Initiative and the Hilton Prize Fellow 2020. He is committed to making contribution to justice and the development of law, while using law as a tool for social justice to create an equitable and democratic society. Thank you, Gitau, and we're happy to have you here. Our third panelist today is Mr. Otsieno Namwaya, who is the East Africa Director at Human Rights Watch. He has been the Kenya researcher at Human Rights Watch since 2012. He published research in 2018 on the obstacles that activists face when campaigning on the environmental and health effects of government development projects at the Kenyan coast. He has primarily focused on accountability for security forces in response to terrorist attacks. He has documented abuses, including extrajudicial killings and enforced disappearances in Nairobi and at the Kenyan coast. Soon after the 2013 general elections in Kenya, he documented gang violence in Western Kenya and the failure of the Kenyan security to respond or protect villagers and police failure to adequately investigate and prosecute the perpetrators. Namwaya has examined abuses by security forces in response to gun and grenade attacks in Kenya's northeastern, as well as government crackdown on human rights in respect to counterterrorism. He has also actively monitored legal and administrative restrictions on media and civil society. Okay, so to start off our discussion today, okay, Kevin, I will go to you as we hope that Otsieno can join us, and then he can catch up where we would have left, where would have been in the discussions. So could you please briefly describe to us what the African Commission does and why is it an important accountability mechanism for human rights in Africa? And specifically to the discussion today, why was it felt necessary by the Commission to develop the guidelines?
Thank you very much, and thank you for having me. So the African Commission on Human and People's Rights is a quasi-judicial body tasked with promoting and protecting human rights and collective people's rights throughout the African continent, as well as interpreting the African Charter on Human and People's Rights and considering individual complaints of violations of the Charter. This includes investigating human rights violations, creating and approving programs of actions towards encouraging human rights, and set up effective communication between them and the states to get first-hand information on violation of rights. And so the African continent, the practice of enforced disappearance has been widespread. However, the available data does not accurately reflect the magnitude of the problem, as many cases are not reported or officially registered, or people don't even know it's enforced disappearance. For example, last year, the UN Working Group on Enforced Disappearances reported around 46,000 cases of enforced disappearance under consideration, and only 4,700 of them relate to the African countries. The lack of awareness about the crime, the rule of law challenges, lack of political goodwill, and reprisals against victims and their relatives when reporting the crime all contribute to a lack of systemized official data of the prevalence of the crime. So the goal of these guidelines is to provide guidance and support to member states of the African Union on the effective implementation of their commitments and contributions to eradicating enforced disappearances throughout the African continent. Back to you, Marie.
So Eva, you played a very instrumental part also in terms of drafting the guidelines. Could you please highlight to us what are the core contents of the guidelines, and also what was the premise behind incorporating them?
Thank you so much, Marie, and thank you, Kevin, for introducing what the African Commission does. Before I start speaking, I just would like to welcome a couple people in the chat room who have helped me in drafting and validating these guidelines, in particular, Mr. Diop, who is the member from Senegal, member of the Committee on Enforced Disappearances, and there are other people that have played quite significant role in making sure that the African Commission passes these guidelines. So let me start with the fact that until this point, the African Commission doesn't have a single instrument that bans the practice of enforced disappearances. And as Kevin highlighted, the issue on the continent is quite prevalent and happens in every country in Africa, and it impacts not just the direct victims, but it impacts everybody, the society, the families, and the countries at large. And so the point behind these guidelines was to raise awareness on the issue on the continent, make sure that the states as well as the civil society organizations start understanding what enforced disappearances are, and hopefully I'll open up pathways for the victims to obtain justice. These guidelines were adopted by the African Commission in May this year and successfully launched on 25th October 2022 during the 73rd session. These guidelines reflect the existing international and regional law and jurisprudence and standards developed by the African Commission in General Comments, including General Comment number 3 on the African Charter on Peoples and Human Rights, the right to life, principles and guidelines on human and people's rights while countering tourism in Africa, the Luanda Guidelines on the arrest, police custody, and pretrial detention, and the Robben Island Guidelines. The guidelines are structured into 5 parts and include the following parts: context of enforced disappearances in Africa, the general principles and definitions, rights infringed by enforced disappearances, states' obligations to prevent and protect against enforced disappearances, and finally, the implementation of the guidelines. I would like to briefly discuss each part of these guidelines. Part 1, as I said, explains the context of enforced disappearances in Africa, in particular speaking on who and what population is affected, such as human rights defenders and political activists, migrants, women and girls and children, as the most recurrent situation in which enforced disappearances takes place, including civil wars, election, protest, and military operations. The Part 2 provides general principles and definitions, including what is enforced disappearance. It highlights the absolute prohibition of enforced disappearance and the continuous nature of the crime, as well as extraterritoriality of enforced disappearances and who are considered victims of this crime. Part 3 focuses on the rights often infringed by the enforced disappearance and standards in relation to those rights. The crime may violate the following rights: the right to life, the right not to be subjected to torture or other cruel, inhuman, or degrading treatment or punishment, the right to liberty and security of the person, the right to fair trial, rights to information, opinion and assembly, the right to truth, and the right to an effective remedy, as well as social and economic rights, such as the right to family and the right to education. These guidelines further recognize that enforced disappearances is a unique and continuous violation that results in the violations of several of these rights that are protected by the African Charter. The Part 4 is the one that is incredibly important, and it sets out the legal obligations that the states have in regards to enforced disappearances. The guidelines do not outline new obligations for the states, but rather affirm already existing obligations states derive from international treaties widely ratified by the African states, such as the African Charter on Human and People's Rights, the International Covenant on Civil and Political Rights, and other treaties. These obligations for states include the obligation to refrain from enforced disappearances, the obligation to prevent enforced disappearance, the obligation to search and investigate, and punish and provide reparations to the victims. The last part explains the steps needed to implement these guidelines, and in particular, the actions that states should take to implement effective safeguards against enforced disappearance, including training and submitting updates on the implementations of these guidelines when states submit their periodic reports to the African Commission. The part 5 also recognizes the importance of disseminating the guidelines and providing the training to states officials and others to achieve the maximum impact of these guidelines in then ending this horrific crime of enforced disappearance on the continent. Back to you, Marie.
Thank you, Eva, for that. I see Otsieno has been able to join us finally. So Otsieno, if you're able to unmic yourself and put on your video, following where Eva has left. So Eva has been able to, even Kevin so far, been able to, give us the importance of the guidelines in regards to what it means for the victims and for the continent. So as you're contextualizing this conversation today by looking at Kenya, could you please let us know the context in Kenya of enforced disappearances, and also, some of the work that the Missing Voices Coalition has been doing in regards to that. So basically, what is the purpose of the coalition, and what has been the contribution in regards to ending enforced disappearances? Otsieno, can you, should I repeat the question? You need to unmute yourself. Yes.
Was that my question? I didn't get it because I was still fiddling with the video and the gadgets here.
Okay. Yeah, just to better context of enforced disappearances in Kenya and the contribution that the coalition has done in terms of ending enforced disappearances in Kenya.
Sorry, I lost you a bit. I didn't get the first part of the question.
The first part is to let us know the context in which enforced disappearances are happening in Kenya. Given the work that you have done and also some of the contribution which has been made by the Missing Voices Coalition. So then we are able to come to a place where we're able to contextualize what Gitau and Eva has so far said as to why the guidelines are an important tool of advocacy in the national context.
Okay, thank you. First of all, you just to apologize that we are in a place where connectivity is poor, so you may have some intermittent disconnections here and there. So while it's still on, just to mention the context, particularly the Kenyan context where disappearances happen, I think the problem that we mainly documented was in relation to counterterrorism, starting around 2007, but gaining a crescendo around 2012, 2013, 2014. When initially we thought ATPU was arresting people and disappearing them, but then with time we came to learn that it was not just ATPU. There were units drawn from different groups. An ad hoc unit called the Rapid Response Team, mainly drawn from the GSU Reke Squad, supported by the ATPU, and the military intelligence, which was arresting people sometimes at night in commando style in parts of the coast region, parts of Nairobi, like Kisii, and northeastern counties of Garissa, Wajir, Mandera, and then either taking them to police stations or not taking them to police stations at all. Where they take them to police stations, they don't register them, and the police don't acknowledge that anyone was brought there. And therefore, families move from one government office to another with no particular information on where their relatives are or any acknowledgement by any government official or office as to where the people who were arrested were taken. Despite the fact that in some instances, the families were present when the person was picked by people who identified themselves as police officers or government state agencies. In one instance in Wajir, I think there was one instance where somebody had gone to a police station with a brother and the person was picked up by ATPU, and then the ATPU handed the person to the military intelligence, and then while the brother was seeing, but then they both denied ever having that person. And to this day, that was 2015, to this day, that person has never been found. So, and these cases have been widespread. At some point, it became big news. The human rights groups were working on it. And one of the challenges we had was how to then collect all our data. Kenya National was working on it. Human Rights Watch was working on it. Amnesty and other human rights groups were working on it. But each of them had different data because we were doing different research in different places and documenting different cases at different depths. So we thought that maybe to help guide the process and so that we can also speak in one voice, we come up with a uniform way of keeping the data and documenting the cases. And that was around 2017, I think, after the elections. And each person was doing sometimes we'll do similar cases, but with different, sometimes different narratives and different statistics and different dates. So the idea then was, how do we harmonize these cases and harmonize the data so that when we cite the data, we all cite from the same reliable data that has been documented and well verified by a central agency that we can all refer to. And that is, I think it's from that conversation that I think Amnesty also took the lead, and then the Missing Voices Initiative came up, and the Missing Voices Initiative has basically been able to harmonize that approach to disappearances and killings to this extent, and therefore we are able to cite the same data with the same information. Thank you.
Thank you for that, Otsieno. Kevin, I'd like to come to you. I mean, Otsieno has brought out, the challenge that there is in terms of balancing international security and rights. So in regards to the applicability of the guidelines, at the national context, what do you foresee as other challenges which maybe might be encountered?
I think the first would be the guidelines came in to work hand in hand with the International Convention on the Protection of All Persons from Enforced Disappearances. And so with Kenya not having ratified that convention, then it becomes quite hard to now start implementing a guideline that its backbone is formed in the convention. So that would be a challenge. Then legislation to criminalize enforced disappearances, still we don't have it. We also, I think among investigative agencies, they don't quite understand what is enforced disappearance. So there's an issue of capacity as well. So you'll ask them what are the elements they're looking for when they're investigating, and most of them will not have an answer. Then we don't have good forensic documentation systems within the country. You'll find that countries like Mexico, where enforced disappearance is a bit progressed where they have laws actually and are trying to set up systems to investigate the same, they really undergo challenges in terms of identification of the victims once they're found, or the survivors. So there's an issue of DNA collection, which we don't have as of Kenya, and also proper evidence collection in terms of forensic analysis. That I can foresee that being a challenge, which was the point of the coroners. One of the things that was supposed to be done was set up of the coroners system in Kenya, which is still pending. Yeah, I think those would be the main challenges, but I think for me, the starting point would be the ratification of the Convention for the Protection of All Persons from Enforced Disappearance.
Thank you for that. Otsieno, I'd like to come back to you. I know Kevin has highlighted some of the systemic gaps which are there, but I want to think that all is not lost, because every time we have like new policy frameworks coming up, they present new opportunities that that present themselves, you know, in the national space with either regional or international frameworks. So specifically to, in the context of Kenya, what do you see as some of the opportunities which the guidelines of enforced disappearances are presenting?
I think there are a lot of opportunities because the guidelines basically offer the general framework, but the implementation actually still falls on the member states. So generally, the main thing is actually the national law. And if we look at our national law, even before we touch on the guidelines, it is possible if the law is implemented to the latter to stop enforced disappearances. One is that, for example, the military is not supposed to do policing work. So what we have seen, part of the reason some of the cases of enforced disappearance have become difficult to trace and become complicated is because rather than the police arresting somebody, they send the military intelligence officers to pick up that person. And therefore, in some of the instances we saw, is that when the family goes to the police, to the military barracks to ask for their relative, the military basically says, we don't arrest people, go and ask the police. And the police would say, we are not the ones who arrested him, go and ask the military. So it becomes like a ping pong. So one of the things that needs to be done is to just ensure that military do not participate in policing duties. And if they do, there has to be a clear command structure which places them under the police so that the police commander under which the military was operating takes responsibility for the people who have been disappeared. The second thing is under the National Police Service Act, the police are obligated to register in the OB anybody who has been arrested by any of the officers. So some of the actually all of the cases of enforced disappearances is what police do, they arrest people and refuse to register them, and therefore the family cannot tell whether they were in that police station or not. So if we can just enforce that law, then the guidelines will not be coming in a vacuum. But if we cannot enforce even the existing laws, then the vacuum, the guidelines will not do anything, because even those guidelines, there's doubt that we can actually adhere to them or enforce them.
But just to carry on from where Otsieno has left, you've worked in multiple countries in addressing enforced disappearances. So in some of what is highlighted that ought to be done, what are strategies which maybe you could propose not only drawing from the Kenyan experience, but also like from other jurisprudences that you have worked in.
Thank you, Marie. Before I go and address your question, I actually would like to highlight what has been happening, the positive steps that have been happening in Kenya in the last few months or weeks in regards to enforced disappearances. So in October 2022, the Senate adopted the report of the Standing Committee on Justice, Legal Affairs, and Human Rights on the inquiry into extrajudicial killings and enforced disappearances in Kenya. This year, during the presidential campaigns, then candidate William Ruto promised to address the plague of enforced disappearances in the country. Since taking the office, there have been several steps taken to address enforced disappearances, or at least raise awareness about it. First, the President Ruto gave order to dismantle the flying squad, unit synonymous with extrajudicial killings and enforced disappearances, ordered investigation and charges were brought against perpetrators accused of forcibly disappearing 2 Indian citizens in July this year. Further, President Ruto met with the Law Society of Kenya, which urged him to set up a commission of inquiry into extrajudicial killings and enforced disappearances. And he also asked IPOA, the Independent Police Oversight Authority, to furnish Ministry of Interior in coordination with a roadmap to address enforced disappearances, among other things. Finally, IPOA on its own has issued a press release on enforced disappearances, discussing their own investigation into the disbanded SSU unit, as well as investigations into National Police Service action or inaction into complaints of enforced disappearances. While all these activities provide a positive step towards raising awareness of enforced disappearances and show some political will to address these issues that have been impacting families and societies all over Kenya, there need to be more things done to ensure that the momentum is lost. So number one is the political will. In many of the countries that I have worked with, the political will is often the number one that allows for the ratification of the convention or providing for justice, prosecution, and reparations to the victims. So I would advise to keep up the political pressure on the legislative and executive branch of the government to ensure that the crime of enforced disappearances is addressed, that the government carries out investigation and prosecution of the perpetrators, and finally provide reparations to the victims of enforced disappearances. Kevin has already mentioned that Kenya, even though it signed the convention, it has yet to ratify it. So I would continue to put pressure on the government to ratify the convention on the protection of all persons from enforced disappearances. And I would advise the civil society organization to identify the relevant government bodies to set up meetings with them to educate them on enforced disappearances and provide them with assistance on the ratification of the convention. Number three, the point number three is to act unified. The Missing Voices is a coalition that's composed of several civil societies, organizations, and several voices are more powerful than just one. Number four would be do not forget victims. Some of the most successful campaigns eradicating enforced disappearances have been as a result of involvement of the victims. So in Latin American countries like Argentina and Chile, victims were instrumental in pushing the governments to prosecute the perpetrators of enforced disappearances, to provide reparations to the victims, to adopt a relevant legislation, including criminalization of enforced disappearances. Coming closer to on the continent, Gambia, in the recent years after the fall of the Jammeh regime, the victims groups have been quite vocal about their experience. And as a result, the Truth Commission in Gambia actually had a mandate that focused on the crime of enforced disappearances under the Jammeh era. And victims continue to be active even now in ensuring that they obtain reparations and that the government continues the investigations into the disappearances of their loved one. Kenya must criminalize enforced disappearances into the domestic law. You cannot prosecute a crime that is not on the books. And therefore, Kenya must adopt a legislation that would allow for enforced disappearance to become a crime. Kevin has already mentioned that, but there is a lack or gap of technical expertise among the police officers, investigators, the witness protection unit is not functioning effectively, and prosecutor and judges not, first of all, on what enforced disappearances is and how to successfully investigate these crimes, how to collect the evidence, and ensure that the justice is achieved. Number 8, I would like to invite the UN Working Group on Enforced or Involuntary Disappearances for a visit to speak with the government and civil society organization and assist both the government and the civil society organizations through its unique technical expertise to end enforced disappearances in Kenya. And the last point is the one that, again, I would like to emphasize, is make sure that the victims are at the front and the center of this process. Make sure their voices are heard, that they are part of the investigations, that they have platforms to speak about their experience, that they obtain reparations for their sufferings, which include access to medical, psychosocial services, provide them with the right to truth as to what has happened to their loved ones, which is among one of the most important aspects of reparations for victims of enforced disappearances, as many do not have closures for months, years, and decades because they don't know what happened to their loved ones. Thank you, Marie. Back to you.
Thank you, Eva, for such a very concise, outline of strategies. There's a school of thought that says, the more binding treaties that a country ratifies, the more human rights violations occur because states tend to hide behind, I've ratified a treaty. So there's an assumption that, I'm in good standing in terms of human rights standards. I'm just throwing that out there for us to think about, but I'd like us to go into plenary. And at this point, following, the skepticism that I started with, Monsieur Diop is with us today, and he's a member of the Enforced Disappearances Committee in Africa. Bienvenue, Monsieur Diop, and if you can unmic yourself and maybe put on your video, if you can share with us today what you see as the role of the working group in terms of, helping countries like Kenya or any other countries that have not ratified the International Treaty of Enforced Disappearances. And how would that engagement look like? Just carrying on from where Eva had left us. Okay, okay. Monsieur Diop, if you're talking, we cannot hear you, although we see that your microphone is on. Okay, as we give Mr. Diop time to get to us, there's a question in the chat box, which is asking, have other countries criminalized enforced disappearances, and is it an impediment in realizing accountability? It's not addressed to any specific panelists, but any of you can feel free to unmute yourselves and answer the question.
Thanks, Mary. I will take this one. I would say it is an impediment to accountability. If you do not have the crime of enforced disappearances on the book, what do you hold the perpetrators accountable? Some of the countries have legislation that criminalizes torture. Some of them have legislation that criminalizes kidnapping. However, crime of enforced disappearances is not just torture. It's not kidnapping. It's actually much more severe. It impacts not just the victim, it impacts the families, it impacts the loved ones, it can impact the entire community. So the gravity of this crime is much higher than just having a regular criminalization of kidnapping. Further, if you do not have criminalization of enforced disappearances in some level, it's really impossible to also end the crime of enforced disappearances on the ground, because if you can't hold people accountable, that means that that crime can continue to occur. There have been countries that have successfully criminalized enforced disappearances, particularly in Latin America, where the crime is enforced disappearances is synonymous with Latin America. But there are also countries on the continent of Africa that are in a process of actually criminalizing enforced disappearance. So there is a bill in front of the parliament in Gambia. There is a bill in Senegal to criminalize enforced disappearances. And some of the African countries have actually successfully criminalized enforced disappearances as part of the Crimes Against Humanity statute that they adopted pursuant to the Rome Statute. It's still not enough. It needs to go further than that, but ratifying the convention and then criminalizing the crime within the domestic legislature is a good step.
I see there's another question in the chat box, but before I take that question, I'd like to come back to Monsieur Diop and see if you're able to speak to address the question on how the committee can work with countries that have not ratified the international treaty. Okay, we still can't. We still can't hear him. Okay, so there's a question in the chat box which is asking, so it's a two-part question. One, it's asking, if the obligation of reparation presumes also the creation of a reparation fund, or is it left to the discretionality of governments? And then secondly, is a similar reparation fund foreseen in the context of Kenya? It's two, but maybe Kevin can take the second part and Otsieno can add to that. And then maybe Eva, the first part, in terms of, what does it mean for a government in establishing a reparation fund?
Thanks, Gabriela, for the excellent question. So the international law provides that the governments have the obligation to provide reparations to the victims. And those reparations could include several forms, including rehabilitation, restoration to the previous form, compensation, satisfaction, and guarantees of non-repetition. Most often, the most commonly or widely known is actually the compensation, which is a financial compensation to the victims for their suffering. However, it doesn't necessarily have to be. So the government do have obligations to provide reparations, and they can be in several different forms. They don't have to be in terms of setting up a reparations fund. In most instances, that's what they have done. So, for example, I keep going back to Gambia, but the Truth Commission has set up a reparation fund that has allocated approximately $10,000 to the victims of enforced disappearances. However, the demand continues to be also access to psychosocial services, access to education for the children of the victims, returning back the property that was taken away from the victims, as well as, for example, restoring the identity of the kids that were taken away from the family. So there are several forms of the reparations that the government is required to take. I will just quickly introduce the context of Kenya. There have been efforts to actually set up a reparation fund, and starting in 2015, there have been a victim bills that was also introduced into the parliament. However, the political will in Kenya has not been sufficient to push this forward, even though there were money allocated, approximately 10 billion, I believe, Kenyan shillings to address the suffering of victims of human rights violations. But I'll let Kevin expand on that.
So yes, mostly the reparation fund has been for victims of post-election violence cases. In non-political violence, we don't have a reparation fund, and so it's left at the discretion of the particular government agency. And so you'll find that a lot of cases that have been litigated upon, most people do not receive compensation because the government says it's broke. So that is yet to be done, but there's a victim protection fund, but that is different, but that also caters for rehabilitation. They had components of rehabilitation and tried to give the reparation. They tried to come and work like the reparation fund, but even the same is yet to be established. So as of right now, it's at the discretion of the government.
Okay, let's be optimistic that with the new regime, there might be an actual implementation of the fund. Yeah. Otsieno, I would like you to take this question from Thomas Probert. It's asking, should there be greater focus on broader custody safeguards with both police and other justice sector stakeholders in terms of achieving greater awareness of and compliance with record keeping and protection objectives before identifying cases where those expectations are being willfully contravened? The question was put in the chat box. In the Q&A box. Otsieno, are you there? Okay, it looks like he's not on the line. He may have dropped off. Maybe Eva or Kevin, if one of you can take up the question.
Can you repeat the question? I'm sorry, because I can't see it in the chat box.
Okay, it's asking, should there be a greater focus on broader custody safeguards, both with the police and other justice sector stakeholders, achieving greater awareness of and compliance with record keeping and protection objectives before identifying cases where those expectations are being willfully contravened?
Kevin, do you want me to take it or do you want to take it?
Yeah, sure.
Yes. And if you look at the Convention on the Protection of All Persons from Enforced Disappearances, there are actually particular articles that address the issue of custody and the actors that are involved in depriving individuals of liberty. And it requires the states to have proper record keeping, have police officers or the custodial staff properly trained on human rights violations. However, in most instances, this doesn't happen, and it's for several reasons. It's probably likely due to, even if you have the legislature on the books, the fact that they don't have proper trainings, they don't have money to implement a lot of these practices, there's a massive pervasiveness of corruption and impunity in a lot of the African states. And therefore, even though the conventions outlines the obligations of the states to create training and effective mechanisms to keep track of the individuals whose liberty has been deprived, the reality is a little bit different. And the guidelines actually also have a section on custodial, the on custodial settings and the role of the governments and what they should do in terms of record keeping and ensuring that nobody is forcibly disappeared within the prisons and other non-custodial measures. But again, it comes to the matter of implementations and the technical capacities and political will and finances to ensure that this is effectively implemented.
Mm-hmm. Okay. Kevin, there's a question in the chat box, which is specifically directed to you. It's from Noel from Sydney. If you can see that, I've lost my chat box. Okay, Noel, if you can please unmute yourself and ask the question. I've lost the text for some reason.
It's fine. I can see it from my end.
Okay, all right.
And so I think the way that the African Commission is set up, it's through cooperation with the AU, basically. And what can be done to support is, one, there's country reviews every 2 years. So the countries have to report on how they have implemented the human rights status according to the African Charter. So that can be one avenue. There's things like individual cases as well that can be brought before the African Commission, and they're dealt with at that point. But unfortunately, the relationship as it is very diplomatic. And so the African Commission is not an implementer. It can only give decisions, basically. And so they cannot be on the ground doing the work. So I'd say it's to monitor the human rights situation in different countries. In case there are cases, they listen to them and they can render decisions. Yeah, I think in a nutshell, I think that's what I would say. It's not a perfect system. It still also has its own challenges.
True, the Commission can only encourage governments to carry out obligations. Yeah. There's another question from Henry, and it's specifically on the special units, in Kenya, which have been established. Every regime has had some sort of special crime fighting unit set up. So the question is, do human rights defenders know how they can monitor or even engage with the new government so that they cannot form their own new squad? Okay, I think, okay. Maybe Gita, you can take that question. I feel like it's a dilemma. Yeah.
We've seen that every government president comes up with a special police unit. We've seen even police.
Like, what is your prediction with this new regime? Are they they've disbanded the SSU? Is that?
For me, I think what I'd answer with this, and there's a reason IPOA came into play and the ODPP came into play. This came after the 2007 and 2008 general elections, where the police were the investigators, the perpetrators, and the prosecutors. So these independent bodies came into play to just make sure there's accountability at different levels. So if you're able to empower IPOA, that is able to monitor police and how they conduct their business, then I think we'd have a mechanism, and the same as for the ODPP as well. So I'd say, for me, IPOA still, the backstop's still with IPOA because they have a mandate, and you cannot run away from it while they're still in office. Yeah.
Yeah. Okay, so we are coming almost on top of the hour. So final words and part of your final remarks, Eva, if you are able to address the question which I had posed to Monsieur Diop in terms of how the the Committee on Enforced Disappearances can work with countries which have not ratified the international treaty. And yeah, and then you can make maybe additional remarks, and then Kevin can make his closing remarks. And I hope that the chat box is clear and the Q&A is clear. Yeah, I don't see any question, and I think, yeah, we can close with that.
Thank you, Mary. I'd like to thank all the panelists and everybody that has attended this webinar, and I hope it was useful and informative. I will start addressing the questions about the Committee on Enforced Disappearances. Even though, as we mentioned, Kenya has not ratified the convention, they can approach the committee to ask them provide technical expertise on how to ratify the convention. Many of the countries think that in order for the government to ratify the convention, that they already have to have certain things in place, including the law that criminalizes enforced disappearances, effective, investigative powers and all of that, which is not true. It's actually, what's important is the willingness of the government to ratify the convention and then start implementing it domestically. And the Committee on Enforced Disappearances can assist with that, can highlight what steps needs to be taken to ratify the convention and how to take the stocks of the laws and the gaps in the current context of Kenya that would help in addressing the issue of enforced disappearances. And Kevin has already spoken about it. For example, IPOA, the lack of the technical capacity among the police officers, the judiciary, the lack of the forensic expertise. And the Committee on Enforced Disappearances can assist in all of that, at least initially starting the discussions with the government on what they are supposed to do. And on that note, I think my parting words will be, even though I'm slightly more optimistic than a lot of these panelists in terms of what can happen to end enforced disappearances in Kenya, I also understand that the current political climate is not going to last very long. And so I would urge the civil society organizations to actually use the power of their voices and the victims to push the government in next few months to do as much as they can to ratify the convention, to criminalize enforced disappearances, to start the prosecutions and raise awareness on this crime and start helping the victims of enforced disappearances that are way too many in this country. Thank you.
I think for me, one of the avenues that remains quite unused is the working group on enforced disappearances, which Kenya does not need to ratify for anybody to go before it. You can still write to them and they'll use diplomacy to get to know where the case is at, whether it's been investigated, what stage it is at. And so I think, personally, I haven't seen a case from Kenya that has been raised at that level. I could be wrong, but I still believe it remains one of the avenues that we can use as we continue to do advocacy around criminalization, setting up all these systems in place. But I also concur with Eva. There's momentum right now on extrajudicial killings and enforced disappearances. And they say it's easier to hit the road when it's still hot. So right now, a lot of advocacy can be done to ensure that extrajudicial killings and enforced disappearances are actioned on by the government, basically. Yeah, I think that's it from me.
Yeah, thank you, Eva, Kevin, and Otsieno. And before we close, I'd like to read a comment from Monsu Diop, who was not able to speak to us, but his comment says that, the role of the Committee on Disappearances is more of encouraging states to ratify the convention. So their role is more diplomatic than political. And the committee has not had much direct contact with non-state parties discussing their commitment in joining the others in fighting. So I think, particularly on the last part of that comment, that the committee has not had, much contact with non-state actors. I think conversations like this ones are also a starting point, to greater other more follow-up actions. So with that, I'd like to thank our panelists for finding time out of their extremely busy schedules to be with us here today. And I hope the conversation has been enlightening and very helpful and has provided, insights in terms of how, regional frameworks can be used, for advocacy at the national level. And with that, thank you everyone, and have a great rest of your day. Bye.